All right, I guess that is it. Uh, I believe no more students are to join now. So we can start with our session today. Could you please let me know in chat section if you can hear me clearly? Am I audible to all of you? Okay, okay, right. Okay, so let's get started with it. Law, or to be more specific, to name the subject, corporate and business law. In today's class, we will have a background on what is law, uh, what should you expect in the examination, the structure of the examination, what kind of questions will be there, because that is the ultimate goal for our discussion. So I would want to focus on that. Secondly, I would be discussing a very interesting question. Uh, why would chartered accountants need to study law? Like, this should be done by the lawyers. Why the chartered accountancy students? So think about that. And when I come to that slide or that screen, then you can share your ideas with me. What do you think? Why is it important for the chartered accountants? Then we will be digging into the basic structure of the our course. I'll be guiding you through the notes and how to use the slides and which book or which content to be followed, which kit, exam kit to be followed. I'll also discuss about the study hub, how you can utilize the study hub, and then we will start with our first section of the course, that is the basics of the UK legal system. So let's get on with it. Okay. So first thing first, and mind you, when we are discussing different things, if you have during the discussion, if anything comes to your mind, you are always welcome to ask, put it in the chat section, and I'll check it out and I will uh, guide you through it. So need not to worry. Whenever you have a question, just write it in the chat section. Don't worry whether that is during the lecture. I'll check it out and I'll answer accordingly. Okay. For those students, first of all, who are new here, because I see some names who were with me in the previous sessions as well in different subjects. Now, I would like to introduce myself. My name is Muhammad Rizwan. I have been in the field of education generally for past like now 23 years, almost are to be completed. And I've been teaching ACCA subjects for about, say, 15 years now. And with Hamzah Academy, I teach business and technology at FD level. In skills, I teach corporate and business law. And at professional level, I teach SBL. So these are the three areas, and if you can understand that, these are all theory-based subjects. I love theory, and that is interestingly something that most people do not like, or at least if I talk from the teacher's perspective, teacher's point of view, many teachers would not want to dig into uh, teaching theory-based subjects, but I really love it. And maybe that is the reason I am in this education field. I also have quite vast experience of administering and heading different educational institutes. I have remained the principal of different renowned educational institutes in my country. And also, I have worked abroad in Dubai for some time in the corporate trainings and soft skills development. So these are the I have sort of a mixed portfolio, but with that, teaching is the main focus. I have always loved teaching. Rather, I would say when I was doing my masters, I'm pretty sure none of you would have been born by that time because I'm actually quite old. Uh, when I was doing my masters, at that time I started teaching, so I took it as a career as well. Even when I was administering different education institutes, I would teach on the side as well. But now I'm fully involved in the teaching. Okay. Um, let's get on with the first question. And because from the offset, we need to understand why is it that chartered accountants need to study law. Uh, you are not going to the courts. You will be in your offices dealing with the financial situations, or being executives, you will be dealing with the workings of your organization, dealing with different stakeholders. But at the same time, your main task would be like, what is the objective of ACCA? That is to make executives out of you. You will be executives. That is the main purpose of your of this syllabus, of your certification. But then why? Why should chartered accountants study law? Why? What is it? Like, you see, you have studied your financial accounting, management accounting, and business and technology so far, I believe. So those subjects were purely related to either finance or the structure of the business or organization. Uh, if you have chosen any subjects at the skills level, you will again see that most of them, rather all of them except law, are one way or the other related to finance or the setting of the organization. What is this law doing amongst all these finance related subjects? So I would like to hear your viewpoint. Why do you think you are to be told to study law? What is the reason? You can use your chat section to show me your ideas to this particular question, that why do chartered accountants study law? Yes, please. The forum is open. You can write your answers in the chat section. Yes. Anyone? Any idea? No idea is a wrong idea. Just shoot whatever comes to your mind. There must be something that when it came to your knowledge that there is a subject with the name corporate and business law that should have intrigued you, that why are we going to study law? And if some answer came to your mind, just put that answer right away. It's not necessary that it should be the right answer. Don't worry about it. Just, it's a brainstorm session. You can just give your ideas. Doesn't matter if it's a right or a wrong answer. There's no right or wrong answer in this case. Okay, thank you, Muntasir. Thank you. Okay, they have to, very good idea. They have to operate within the country's law. I would request you, whenever this type of a discussion is there, write your answer in the main chat section so that others can also understand what you're saying when you are participating. Okay. Isha says to ensure that business and companies comply with the laws. Very good, excellent, and more or less the same thing, but different words. Accountants, they have to operate within the country's law, and then they also need to know whether the compliance with the law is going on or not. Okay, Arushi, chartered accountants need to have an understanding of the legal system since they will be dealing with many legal works, for example, advisor. Excellent, excellent answer. So you see, anyone else, you can also type in. So I will just discuss upon these. You see, the idea is that as chartered accountants, whether you are working with a firm, or you have your own firm, you are freelancing, you are working from home and advising your clients, whatever you are doing. Okay, we have got more answers. Excellent, Humera. Because we are dealing with the company's finance, which is impacted by the, definitely. Excellent answer. Okay, Agathe. Please don't mind if I pronounce the answer, your names incorrectly. Uh, I just take the letters and pronounce accordingly. In order to write financial records such as taxes. Very good, very good. That's also correct. That I'll come to it in a while. Excellent idea, Agathe. Now, because whether now I was saying that whether you are working as a freelancer, as a sole chartered accountants working for different clients, whether you have your own firm, whether you are working in a firm, whether you are working in a company, may that be in the position, because earlier when you joined, that will be a lower level position. Obviously, definitely you will not be a chief executive right away. You have to get promoted for that position, but you will not be working in a vacuum. Like, you see, sometimes when I in my physical classes, I guide students that why to study this subjects and think beyond your certification, think of your professional career as well. That how will you work with other people? They automatically think I'm talking about a job. They say, no, sir, we won't do job. We will open our own business. We'll open our own firm. Okay, fine. That is not a negative. You can do that, but still, you will be dealing with other people. You will be dealing in within the domain of some country's laws. So the first thing is that you have to be aware of those laws. In law, I use a general statement which is very common, but in law it matters a lot. The statement is, ignorance of law is no excuse. I'll repeat, ignorance of law is no excuse. I'll even type it. Ignorance of law is no excuse. This means that whenever you are operating in an area, working in an area, whether that be a job, whether you are still living there, where you're driving your car, whatever you are doing, if you break law, and then your defense is you say that, oh, sorry, I did not know about this law, that is not an excuse. You will still be dealt with according to the law. For example, if suppose in my country we deal in kilometers per hour, the speed of the car is in kilometer per hour. If it is in miles per hour in your country, do let me know in the chat section. But otherwise, I believe it will also kilometers per hour in your country as well. Let me know then in the chat section. Okay. Suppose on the main highway of our the connecting highway between the cities in my country, the maximum speed limit is 120 kilometers per hour. Now, I go to another country and I haven't studied their laws, and I move on to their uh, highway as well, and I'm driving over there. Let's not discuss about that. I will get a license, and obviously I will know about that. Just forget that about for a moment. Just focus on this thing, this example. And I'm driving at 120, just like I do in my country. But the speed limit there is 110 or 100. Okay, I'm stopped by the police. They tell me that I was overspeeding, and I tell them, no, I was not overspeeding. It was 120. They say 100 is the limit. Oh, I'm so sorry, officer. I did not know about that. Do you think that will exempt me? Not at all. Because they will be dealing according to their law, not by my understanding or my ignorance. This is the key. Now, because in business situation you have to deal with many legal areas. Almost for every area, financial area, there is a legal cover to that. There is a legal requirement of that. Like for example, in your BT, you would have studied that what are the what are the legal implications if a company does not follow the requirement. For example, audit is a requirement. If a company audit is obviously a sort of a financial area that you will be studying in your skills as well. But if you don't do that, you will have legal repercussions. This means that ignoring that or saying that I did not know about it, it's not going to help you. So, summarizing all of your answers that you mentioned here, the first thing you need to remember that when we are studying this subjects LW law, it is not required for you to develop skills as a lawyer. Remember, many a times this thing comes to students' minds that, for example, when we are discussing, I'm discussing a certain topic, and because that is not the requirement of the course, I don't go into that part of the area. Which part of the area? See, suppose this line represents the whole knowledge of law, complete knowledge of law. It includes all types of laws. For example, property law, family law, traffic laws, business laws, company laws, everything. Now, your job as chartered accountant is only this much. This is your portion. Chartered accountants are required only this portion. This portion is left for the lawyers. Okay. Now, what does this mean? Many a times when I'm teaching a topic which is related to this area, which is the requirement. For example, I will tell you about the basics of the contracts. And one interesting part would be that contracts do not need to be in writing. Okay. The students will certainly, either whether they ask or not, it will come to in their mind that, okay, fine, then how can it be proven? Now, as soon as that question comes to your mind here, how it can be proven, how the judgment is passed. Uh, so those portions are out of the requirement for your course. You are not required to understand or develop the skills as a lawyer. How do we investigate? How we trick the other party into with our questioning? That's not required of you. What is required of you then? Okay, number one, you have to be aware of the legal issues. That is the first thing. Now, I'll in a while explain to you different areas that are included in our course. So all of those areas, you will see that it will be related to different activities in the business, different structures of the organizations. So you need to have an awareness of all those issues. Or in other words, you will have to cover the surface of this ocean, which is called law. You're not required to dig deep and dive deep into it. Okay. What is the other requirement? Why are you studying it? You should be able to judge when outside assistance is needed. Okay. You are suppose a chartered accountant. You are suppose a chief executive officer. You are suppose a non-executive director. Now, when should I consult a lawyer? That is the requirement of this subject. That skill you need to understand. And how will that? Because when I give you different areas and we discuss different topics, you will know when you are in the your career and your profession, and you something comes across your mind, this knowledge will kick in. Oh, so this is the situation that may get me into trouble. So I should get a lawyer and I have to discuss with him. Okay. Now, when you discuss with him, I'll jump to this one, how to communicate with lawyers. Now, you see, when you as chartered accountants, you guide a client, or you suppose write a charter your audit report. Do you think that audit report will be in plain English? No. It will definitely have some jargons, some terminologies from the finance. That is the requirement of the report. Now, if somebody is not aware of the financial language, he will not be able to understand. Okay. Similarly, when you go to a lawyer and you discuss a legal issue, because it is a legal issue, he will have to use the legal terminologies with you. Now, if you do not understand those legal terminologies, you will not be aware of the whole focus or the whole picture. You will not understand it. Because communication is the key, you need to know what the other person is saying. For example, right now, if I use a term, say, obiter dicta, that is a legal term. Ratio decidendi, onus of proof. You don't understand. Maybe you have heard it somewhere, but you do not understand its actual application in the law. Where is it used? What does it actually mean? So, with it is important. This subject is important so that when you're in your career, when you are discussing, you are having a discussion with the lawyers, you would know what do they mean. Similarly, another example in your BT somewhere you would have studied the criminal offense or a civil offense. What does it actually mean? In today's class, we will discuss about that in detail. Okay, finally, and because of this, I use this statement. I really like this statement. Law is the language of business. I really like this statement. Think about it. Whenever you are dealing, for example, you are hiring or you are being hired, you are given an appointment letter that has a legal importance. So the language used in that has to be legal. When you're making a contract dealing with somebody, whether you are going for a bank loan, whether you are issuing shares, whether you are taking a credit from someone, all of this has a legal implication. So you need to understand the language of the business, which is law. And finally, it has its financial implications. You need to know which laws require what level of understanding and what actions do those laws require of you as chartered accountants, as business owners, whatever the case may be, whatever type of stakeholder you are, whether you are a supplier for goods, whether you are a organization which sells shares, whatever it is, you need to understand its applications in the business world. Okay, so I hope with that you are clear on what is required. Let me summarize it all for you in one go. Do not study this subject just for the sake of passing the paper. Understand this, that this paper has a wider application in your career because it covers all the areas, whether you are a sole trader, whether you are a partner, whether you run a company, whatever it is, it will have applications on your career. So you need to understand it accordingly and take it with enthusiasm and think that, okay, fine, I'm studying this and there may be a circumstance in my future, in my career, that this thing will be this area, this subject matter, this point will come, it will be in front of me, and I need to prepare for that. Okay, just a little bit about the exam format. This is the only paper in the skills level which has the same format as the FD papers. It is a 2 hours CBE and it is only MCQs and MTQs based, just like other subjects in the FD level. You will have about 25 2 marks questions, and these are usually application based. Or in other words, scenario based. You will have to apply knowledge. Then 21 marks question, usually these are knowledge based. Usually these are true or false, or sometimes they have 3 options out of which you have to choose one. These are rather simpler ones, and I say that these are bonus marks. If you have studied through all of the content and practiced your MCQs as I guide you, you will be able to get all of these 20 marks very easily. Then you have 5 6 marks multiple tasks. Not, yes, these are objective, but multiple tasks or multitask questions. Usually they have two or three rather uh, uh, parts of each on based on each scenario. There is a bigger scenario, and you would be familiar with it if you have covered your BT, more or less the same area. Now, first of all, our ultimate goal is to, the first primary goal is to clear the paper, and in the longer run, to have the knowledge for our career as well. With my experience, uh, I discussed with the students after they have gone through their paper. Usually, the physical classroom teachers, because they are students, because they meet us on almost daily basis, or they come in front of us even if the course has finished. So it is easier for them to get the idea from them. But I urge you, whenever you complete your paper, do give me feedback on how well you were prepared, whether the paper was expected, something unexpected, or things like that. But uh, with whatever I have experienced, I have gained feedback from the students that if they have gone through all the content as I explained, and they have completed all the practice question and tests and mock that I give to them, there is excellent chance of getting above 70% marks easily. This is not a difficult subject, remember. This may seem a little complicated, but the reason is that you haven't studied law in any area. If you have studied a little bit of law, you will find it very easier. But this is my job to make it easier for you. It is your job to study the content and perform the practice questions as and when I give them to you. So with that, you can rest assured that you can easily get above 70% marks. Some students have also taken above 80% marks as well, even though this is a theory-based subject. And in theory-based subject, it has always been difficult for students to get higher marks than the numeric based subjects, because this is the nature of the theory. There is nothing wrong with the students or the subject. This is the nature of the theory, because there are many words, vocabulary is available. Obviously, English is not our first language, and even for that matter, many English students, British students, they are not able to achieve above 90% marks in most of the theory subjects. So don't worry about it. But if you go through it properly and practice properly, you will get above 70% marks. Okay, just a little bit about what is the syllabus, how it is broken down, what are the requirements of the syllabus, and then we will take a short break, and then we will start. After the short break, we will start with our today's session of the content. Okay, the syllabus is broadly divided into two main areas, the business law area and the corporate law area. Corporate deals with the business organizational setup. So initially we will study English legal system. Then we have a major chunk of contract law, then law of torts, and then law of employment. In corporate law, we will have law of agency or agency law, partnership law, company law, another major chunk, corporate governance, how to deal with the companies, and then a small chapter on fraudulent behavior or criminal behavior in the businesses. I'll discuss a little bit about where to or how to study the content. Now, basically, for your content you have and your practice, you have three major sources. First is the books or publishers, that is Kaplan and BPP. And in addition to that, you have your own study hub, which you can access. Now, at BT level, I suggest Kaplan, because that is usually the beginning for the students, and they need to understand the content. And Kaplan's language is a little bit easier for students. But for law, I see that the language of Kaplan is way too easy. You can go through it as well, but it is way too easy. I mean, as chartered accountants, you need to have a certain level of commercial acumen, which will be required in your other subjects as well. Commercial acumen means the understanding of the commercial environment, and that reflects in your understanding as well as your expression of words. Like for example, in when at BT level, we normally use minimization of risk. Uh, but later on, when you study in your higher level subjects, the word minimization is not a proper business word. The proper business word is mitigation of risk. This is how it is different. So when you obviously you have to prepare alongside for your future subjects as well. For example, in SBL, when you are writing your answer, the examiner expects of you to use the commercial language, the business language. If you are using plain English, in some points you will actually lose your points, and in other cases you will not put a good impression on the examiner. Therefore, you need to understand all of this. For that, I recommend that you follow the BPP course. And my slides also are based on BPP. The chapter numbers, etc., are based on the BPP and its format. The content is the same. The topics are the same. The explanation may be a little bit different. I will be uploading the BPP book and kit on the portal as well as when I am through with the chapter, I will upload the slides as well. Whenever there is a requirement, I'll upload the tests as well, and you will be told about it well in time. There will be at least 3 tests and a mock official for this. And after you have completed your course, I'll also be giving you some additional practice mocks, which are based on my own understanding, my own collection of questions, some from past papers, and some from the ACCA's paid mocks that students shared with me, and I have developed those as well. Rest assured that if I'm teaching you uh, uh, from this, the BPP, if there is any topic which is not included in BPP but is there on the uh, study hub, I will also include that and show it to you. So you do not need to worry about it. However, still, if you want, you can go there and study over there. But rest assured, if you stick to the lectures that I provide you and the practice that I provide you, and in the end, yes, it is recommended when you are through with your course, then you can go to the study hub and practice the questions. That is fine. But when you are studying the syllabus and you go to sometimes to one source and then the other, and then the usually students get confused. So I suggest that you stick to this and you follow the BPP course for now. Okay. We'll take a short break. You get freshen up, you drink some water, get prepared, take your pen and notebook, get ready. We'll take a short 10 minutes break, and then we will start with our topic of discussion and the course content that shows us what is law and how is business run in a, or what is the situation, political situation in UK and all of those area. We'll start with our first topic, English legal system, after a 10 minutes break. In the meanwhile, if you have any questions, you may please post uh, in the chat section. I'll answer that. Okay, now we will be starting with the first chapter, uh, and we'll try to understand the basics of the English legal system and the political domain within which it operates. First of all, a general discussion on what law is and what is its purpose. Law is basically a set of rules to do what? Of conduct, how people interact with each other, recognized and applied by the state. So this means that state is the main source of the law to members of the community in a society and enforced through the courts. So it is made by the state and enforced through the courts and other related institutions. Now, the general idea is that no society can live without laws. Who makes those laws? That is a separate story. Whether that was a king that was making the law, whether that is a lord in a particular area, or whether these laws are good or bad or whatever it is, laws have to be there. Without law, there will be a total chaos. Nobody would be able to do anything, and in one way there will be a law still, which will be might is right. Whoever is the strongest and mightiest, he will be enforcing his own rules on the weaker. And that seems to be the basic purpose of law, that to balance out the weaker and the stronger. In many different cases, when we are studying law, we will be studying that if there is a dispute, if there is an issue between two parties, law would want to balance the difference of power between the two. For example, I ask you, and you can write your answer in the chat section. I'll give you a situation, a relationship between two parties, and you tell me who usually is the weaker party in that relationship, and who is the stronger. Or rather, you should write the weaker, and I'll understand. One relationship between employer and employee. Relation between employer versus employee. Who is usually the weaker party in these two? Employer is the weaker party or employee is the weaker party under normal circumstances? What do you think? Excellent. You see, because employer is the one who's in the commanding position. Yes, Muntasir, you are right, it depends. But that's why law has its beauty. There are different contingencies, but the structure of the law or the mentality of law is such that we have a general principle and then we have an exception to it. General principle and exception to it. We will be going through this again and again throughout our course almost, that there are general principles which generally apply and some exceptions. But under normal circumstances, we see that usually the employee, because he is in need of the job, and the employer gives the job. So for example, when recruiting, it depends on the employer who he gives the job to. And similarly in all other cases, up when there is appraisal, when there are bonuses, so employee under normal circumstances is the weaker party, is at the receiving end of the injustice. Yes, sometimes the employer can also be at the receiving end in the injustice. For example, an employee leaves the job without any notice, and he has the confidential documentation of the organization and he leaves. Obviously in this case, he is the wrongdoer, he is the person who has unjustly acted. But under normal circumstances, it is the employer. Similarly, another situation where we can say between the seller versus buyer? Who is usually the wrongdoer? Again, there could be exceptions, but what is the general case, usual case? You see, in online purchases, this is a very common thing. Sellers present their products of excellent quality. They take pictures with an angle and with the color schemes and their photoshopping, etc., that the object looks way better than it actually is. So the buyer is at a weaker position because he cannot physically check. He's dependent on the video or the picture that has been uploaded by the lawyer, by the seller. Now, these are just two examples. What does law do about it? Law tries to make sure that the stronger party does not take benefit of the weaker party. Now, in this case, Muntasir, your question will also your point will also be cleared. If the employee is doing something wrong, employer will be protected. If the employer is doing something wrong, employee would be protected. But the nature of their dealings is such that usually the employer or the seller are usually are the wrongdoers. They are the stronger ones. They have more power, and the extent of their power is such that they may try to abuse that power. They may exploit the other party. Therefore, law has different law. What does law do? For example, there is an employee protection law. We have a whole two chapters on that, employees and their protection, so that the employer cannot terminate the employee without without a legal cause. Similarly, law restricts the sellers to make sure that whatever they describe in their online shops, the product should abide by the, or it should follow that description. This is a very important area. Please understand this. Law does not say that the product should be like the picture. It says it should be like the description. What is the difference? For example, I want to buy a study table for myself. I go on the internet and whatever online shops, say Amazon or whatever, I look it out and I see a picture. I like it very much, and it seems like this is the right size for me. And right size would be I would want a 4 feet wide by 2 feet, 4 feet long by 2 feet wide table, so that I can put my laptop and other gadgets on it and I can teach properly. Now, when I order it, the table comes to me and it is this size. I'm surprised at what happened. And I try to sue that person. He is not bound by the pictures. What I should have done? What do you think? As a buyer, what should have I done when I was making a decision to buy that product? What do you think? Anyone? If I'm buying online, should I only focus on the picture, or is there something else that I should check? There could be a few things. Okay, ask for a proof like a picture, but the picture is already there. They have put the picture of the table. Still, I got the wrong one. Yes, that's a good idea. Check the dimensions of the table. Suppose they have put the dimensions in the picture that this is the width, this is the length, then that is fine. Otherwise, it should be in the description. Excellent, Isha. I could also go to check the reviews. I should check the reviews, what the other customers who have bought the product are telling about it. But there is a trick to it. That's why I told you to give me many ideas. You see, the seller is not bound by the reviews of the people. By law, he is bound by his own description. If in the description he has mentioned that the table is 4 feet long and 2 feet wide, and then if the table comes to me this size, then I can sue him. Otherwise, If the table, if the correct dimensions are mentioned in the description, that this is about 4 inches by 2 inches, and still I buy it just by looking at the picture, then he is not responsible because he gave the correct description. What the customer says, that is for my benefit, but that does not have a legal repercussion on the seller. So you need to understand. See, when we talk about why do chartered accountants need to understand this, so that you have an awareness of the situation. What now? Consider you are the seller. Okay, you have written correct description, but there are certain bad reviews. Still, when somebody buys that product, he will, now you are the seller, he can sue you on the description. If you have given the description correct, he cannot take the other people's reviews against you. See, you are safe. This is how law works. This is how we have to understand the whole situation. Okay, now a little bit about the structure or the legal structure of UK. What is it? How does it work? UK is basically uh, a constitutional monarchy. Constitutional monarchy means monarchy, first of all, a monarch or the king, or previously it was the queen. If you have understand the whole concept, the royal family rules a certain area. Uh, but from our perspective, what does a king do? Yes, he rules, but from legal perspective, he is the one who makes the laws. His word is the law. Whatever he says goes. Whatever he says, it has to be applied. Okay. In the UK and in many Western countries, historically there were kings and queens, and monarchy was uh, the law, and that was how things used to work. Without going into deep much historical details, what happened that uh, there were different wars within the countries. We call them. I seem to forget the specific civil wars. Yes, civil wars and things like that. Because sometimes you see, if you got a good king, he will make good rules, good laws. But most of the time, what they saw, because there was no restriction on what laws can the king make, they usually, because of this power, they got different laws and usually were very problematic for the common man. This saying came from this background, that power corrupts and absolute power corrupts absolutely. This was their basic idea for the modern democracy. They said that if only one person or entity has the power to make and implement the laws, and then uh, make decision based on those laws, then that will corrupt that person and it will not be good for the people. What did they do? They split it up. This is called the trichotomy of power, the structure that is in front of you. Trichotomy of power. And one way or the other, we see this in modern democracy. What they did do, they removed the power from the king. Then they did not give it to one institution. Rather, they gave that powers, they split it up and gave it to 3 institutions. Now, what are those powers? First is the parliament. In next session, we will study in detail the structure of the parliament and how the laws are made in that. But what is the function of the parliament? To make and change laws. That was one power of the king. But the parliament cannot implement laws. For implementation, for putting it into action, we have the executive government. A simple example that I give is tax laws, for example, are made by the in the parliament, but you do not pay tax to the parliament, to the parliamentarian. There is another section of the government, some other institution, some tax collection authority, who follow the law made by the parliament and they collect the tax accordingly. But they cannot make the laws. Law making is with the parliament. Okay. What is judiciary doing then? Judiciary is the one that has to make the judgments on the law. If somebody breaks the law, the executive government cannot punish them or cannot pass judgment on that. For example, police. has the power to put law into action. But if somebody breaks the action, they have to take them to the court, and the court decides. Obviously, some matters, for example, if somebody has broken the traffic laws, they will right away give them a ticket. But if that person disputes that ticket, for example, overspeeding, he says that I was not overspeeding. The executive management cannot make a ruling on that. Now this is a dispute. They have to go to the courts and get that done. Now courts obviously also cannot make laws. They have to pass judgment on the law, plus they interpret the law. What does it mean? You see, when the law is made in the parliament, it is not just for 1 or 2 years. This is usually for a longer period of time until it is revoked, until that law is cancelled out. So, when a law is made, for example, it cannot foresee a possible scenario related to this law 10 years after. Obviously, human beings have their limitations. They can think, for example, you see, nowadays we have, previously we had petrol vehicles, diesel vehicles. Now we have electric vehicles. Now they are making laws for that. Sooner or later, we will have some new form of energy, for example, hydrogen based cars, or maybe some new form. We don't know. Maybe after 10 years, there is another type of technology. Now, what do we need to do? Should we change laws all the time? It will take a lot of time and resources of the parliament to make laws all the time. So they make a law in such a way that it should be implemented in future as well. But when the dispute comes in front of a judge, so now, for example, you are a judge and a dispute comes to you after 10 years or 20 years of that law, you have to, now judge is bound by law. He cannot make a decision from his logic, from his own will of the heart. He sees that, oh, this person looks like a thief because I was robbed by such a person who looked like this, I will punish him. No, he has to look at the proofs and evidences and discussions and uh, and the law, and he has to make decision based on that law. Now, if the law is ambiguous for that particular situation, what does he do? He has to interpret the language of the law and implement that on the case in front of him. How does he do that? That is the next section that we will discuss, that how do judges interpret this ambiguous situation of law. So that is the whole scenario. Now, neither of the body has the absolute power. Parliament can make law but cannot implement it. Executive management can implement the law but cannot make it. Judiciary makes judgments on the law or interprets it, but they cannot make the law. So this is called the trichotomy of power. They have split the power. So coming back, the UK is the constitutional monarchy. So constitutional means now it has this system and it has democracy per se. But in many other countries where there are no kings, they have democracy. Why do we call it a constitutional monarchy? They have a specific constitution which declares them there will be elections and there will be a parliament, etc. in the structure, but still they also have a king. Currently, it is King Charles III who's the king. Then what is the role of the king if he's not making any laws? It is his role is apolitical, also referred to as crown, the king or the crown. The position of the crown is apolitical. Apolitical means he does not have any say in the lawmaking. They have kept the kings as a tradition, as their attachment to their history, which was they ruled over the world for quite a lot of time. They English, French, like okay. So, but apolitical means when the parliament makes laws, they are not required to be approved by the king. What does it mean? The law will be sent to the king for signature, which is called royal assent. But if the king does not have power to deny it. He cannot say that I do not want to sign it or I do not approve of this law. This is not his power anymore. That power is with the parliament. This is what apolitical means. With this, if you have any questions, you may please ask. If no question, then write no question and I'll move to the next slide. Any kind of question you may please ask. No questions so far? Okay. Now, I'll discuss with you uh, types of law. You see, when we are discussing the types of something, we have to have a certain criteria, like on the basis of what are we uh, discussing or describing or categorizing. For example, if I ask you, tell me the types of human beings, the first question should come to your mind that on what criteria, whether I'm asking about on the basis of gender, I'm talking about on the basis of age, I'm talking about on the basis of the social status, I'm talking about on the basis of heredity of the nations, of what is the basis. So when we are talking about the types of law, there are categorized into different segments. Now, first segment is based on the source of law. Where is the law coming from? Two basic are the common law and equity. Now, this is important, this area, because in future, when we will be discussing different elements, different segments of law, we will be referring to it. For example, in employment, we will be saying that this is the common law duty of the employer. This is the common law duty of the employee. So that is the first part that you need to understand. Now, what is common law and what is equity? Common law formed on the basis of the local customs, which is also called law of the land. Not per se now, but what does it mean? It has a historic importance. You see, in the very early days, when the humans, like, they've lived in tribes and little societies, the cities were not built. Do you think there were no laws? There still were laws, but those laws were implemented in a certain geographic area or for certain tribe or for certain township, because travel was not easy, communications were not easy, obviously internet was not there. And I'm talking about the times before, like, even the telephones or even the railways or things like that. But because the tribes were there, little townships were there, they still had some laws. Now, when the central governments evolved, and this happened in almost all the countries, when the central government evolved and there was a central body to rule, in which in our case we are saying it was the king, they did not abolish all the laws that were locally made by the people. For example, in a township, if they had made a certain law that if somebody steals, we will give them this punishment, they did not change it. That kept on going. So that part of law which evolved from the local customs, it is known as the common law. Later on, uh, when the courts were made by the central government or the king, and the judges were there, and they also solved the disputes between people, they also gave regard to that common law. For example, in my area, if there is a dispute over the land, the people, the elders of the village, they get together, and the person who has claimed over the other person that this person has acquired my land, it is my land, and he's occupied it, then the elders of the village, based on their history, their tradition, they make a judgment. They would call for witnesses and all. Judges applied the same thing, but when it was applied in the courts, that common law became the case law. Or in other words, we can also say case law is the judges made law. But what was it based on? It was based on the local customs. The problem with the common law was whenever it ended, the result, if it was in the favor of the person claiming it, it used to be monetary reward. For example, if my laptop gets stolen and I claim on somebody that he has stolen and it is proved, then the court would, according to common law, tell him to give me the value of that laptop. For example, it was a latest Lenovo laptop or an HP laptop. So judge will say that this is the market value, give him the market value. Okay, that would be monetary reward. But I'm talking about equity. Sometimes the monetary remedy is not sufficient. For example, what if I had very important data in that laptop? Money cannot recover me that data. I'll give you another simpler example. Suppose I am wearing a watch and that watch has been passed on to me over generations. My father had it, and his father had it, and his father before him. And it is coming in generations, and my son would inherit it. So it has a sentimental value to me. Now, if the judge says that, for example, if it is a Citizen watch or if it is a uh, uh, whatever brand it is, judge says that okay, this brand watch is available for this much price in the market, and he says to the thief that give him this much amount. Now, I could say that judge, that amount could buy me a watch, but it cannot buy me the sentimental value. It is not sufficient for me. Now, in certain circumstances, the judge would order the other party to do something or refrain from something. Now, what does it mean? If a person steals a computer, he may be ordered to repay the value of the computer, monetary value, to the wronged party. That is the common law. Just but not fair. What does it mean? Just means, okay, fine, I am getting what I lost, but it is not fair because it is not giving me the true value. Equity court may order the computer to be returned. Now, this is the part where you can say that what if he has given it to somebody else? What if he has sold it further? That's not our concern at the moment. We just need to understand equity. This will be the more equitable solution. I'll just give you another example. This is my favorite one. Suppose I have my house. It is a two-story house, and it is quite an old one. It does not have a basement, so there is the foundation is not very deep. It's not a very strong foundation, but it works for me. Now, just beside my house, another person is going to start building his own house. I know that if that person starts digging the land, he will construct a basement, and that because my foundation is not very strong, this side wall of my house may fall. There is a great chance for that. So I go to him, I tell him that could you please not do that. Now this is again his rights as well. He has uh, bought a piece of land and he wants to construct a house for himself. So law also does not provide me the full uh, power over him. I cannot stop him from constructing his own house according to his own will, just because I will have a problem. Okay, what can I do then? Suppose I go to the court, and if I ask the court not to permit him to build his house, obviously the court cannot do that. Court may tell me that you see, suppose if your what best we can do is if he builds the house and then your wall falls because of his building the house, you can come back to us and we will give you the monetary compensation. We will ask him either to construct the wall for you again or he will give you the money. Now, this is a very important point in the legal discussion in the UK law. In these types of disputes, when there is a dispute between two people, I'll talk about it in private law and the criminal and civil law in detail. When there is a dispute between two people, usually there is no concept of punishment in the UK law. Now, again, this is a general rule. There will be an exception to that. There is no rule about this. It's not like punishment. It is only compensation. Meaning, if I get a loss, if I get a uh, if I get hurt, if my property gets damaged because of the action of the other person, he will only compensate me for my loss. That's it, up to that level. So the court says that okay, fine, if let him start his work, if he starts the work and if your wall falls, then fine, come to us. We will tell him, he will give you the money to repair the wall, or he will repair the wall for you. He cannot get the whole house painted for me. That would be punishment. He will only compensate me up to the level of my loss. This is the key area. Remember that, and we will be discussing it in the contracts to detail. Okay, fine. That seems like a good solution. This is a common law solution. Now, I tell the judge that, judge, this is not sufficient for me. Why is that? Because of I have family, I have ladies there. Uh, like if this wall falls, obviously it will take about a month or so to reconstruct the wall. What will my ladies and what will I do up until then? It is not a sufficient thing. Let me move my family to another house for some time until he constructs it, but that will take about 2 weeks. Loss is okay, fine. Now, what I am telling you now is the equity judgment. Court will tell the other person that, okay, fine, we will not stop you from constructing your house forever, but stop constructing your house for about 2 weeks. Let him move his family, then you start the construction. This is a more equitable solution. This is called injunction. When the court stops somebody from doing something, that is called an injunction. We'll study it in a while as well. So this is equitable. Okay, fine. Both are happy. He is happy. Okay, fine. I can delay for 2 weeks. And I say, okay, fine. Now, if I move the family and then still if the wall breaks, now this is a new case. Now, again, I will have to go to the court and now I can ask for the compensation. At the same time, I cannot ask for the compensation and equity rewards both at the same time. It will be this or that. So this is the basic idea behind. So equity is a non-monetary reward in which a court will either ask somebody to do something or refrain from doing something. And there are other things as well, which we'll study in the contract law in detail. So this is the comparison between common law and the equity. Now, the third type of law here, who makes that, is the statute. Now, in your BT or your other finance subject, you would have heard the word statutory or statutory. It is the law which has been made in the parliament. How is it compared to the common law? Common law is the law made by the due to the local customs. But when a law is debated upon in the parliament and then it is law, that law is made, that is called statute. And statute is the superior. If a statute is against a common law, then the common law is gone. Statute will prevail. For example, I understand that you know the concept of minimum wage. You would have studied in your finance portion. Minimum wage is the concept that government decides that this is the minimum amount of payment that should be given to the labor. Suppose if in an area the usual wage paid to employees is suppose $10 an hour. This is because this is on the local customs, we can say this is the common law. But government says that now minimum wage will be $15 per hour. This is the minimum wage. Now they are in conflict. It can be this or that. It cannot be both. So, well, it can be both if you follow the statute. But if the local people say that no, our local custom is we pay, local employer says that we pay $10 an hour. This is our local custom. No, statute is higher. If the statute will remove the common law and it will be implemented, because common law, if there is no statute and there is no statutory requirement, then the common law will prevail. If there is a statutory requirement and it is in conflict with the common law, then the statute will prevail. Similarly, if there is common law and equity, if they are in conflict, equity will prevail, common law will be. So in category, it is common law, then it is equity, and then there is statute. So this was based on the basis of from the source of law, where does the law come from. Next is the categorization of private law and the public law. Public laws are those which deal with the matter related to the society as a whole. General laws which are applied to everybody. Everybody has to follow that. For example, tax laws. Tax law is not made for a specific organization. It is a general law which is applied to everybody. Constitutional law, the constitution of a country, for example, how the elections will be conducted, how the prime minister will be chosen, etc. This is applied to everybody. That is the constitution. Similarly, criminal law is for everybody. Private law is actually the deals between the two individuals. These individuals could be two individual people. This could be two organizations. This could be one organization and one individual. But it is like, for example, contracts. If two people have made a contract with each other, it does not affect the whole society. It affects only those two people. Similarly, family matters, things like that. Tort law and property ownership. This is between the uh, these two people. Then we have a bigger topic, which is the criminal law and the civil law. Criminal law is that one that deals with offensive behaviors. Okay, what is a crime? Generally, we can give examples, but remember that crime is an action which is declared as a crime by the government. What does it mean? You see, certain actions are considered crime all over the world. For example, murder, assault, theft, breaking of traffic signals. These could be crimes anywhere in the world. But then there are certain crimes which are not declared as crime in some parts of the world. For example, say money laundering, say bribery. Now, in your BT course, you would have studied about money laundering. You would have studied about insider trading, or you would have studied about bribery. These are all criminal offenses, crimes in the UK. But for example, if I tell you that, say, in a country, say Ethiopia, whether money laundering is a crime or not, you cannot tell me. You will have to study the law of that country, or at least Google it, and then you will know whether that country has declared it as a crime or not. If they have not declared it as a crime, it's not a crime in that country. So crime is something in action. For example, if I punch somebody in the face, is that a crime or not? It depends on the law of that country. Usually, assault is a crime in all the countries of the world. But for specific situations, we need to know it. Why is it important? We'll discuss in the later slide. Then there is other part which is called civil law. Injuries to private people, private parties. Here, injury means loss. Another important understanding of law. Whenever we use the word injury or injured party, it means whose rights have been violated, who have suffered some kind of a loss, not the physical injury. He is not injured actually, what we call in English, a person who's injured. It's not injury, that injury. Injury in law means some kind of a loss. If the law wants to tell you about the actual injury, they will use the word physical injury or personal injury. So physical injury, for example, if you are driving very fast and if you hit somebody, he's injured and he's physically injured. Means he has received an actual injury because of you hitting him, and then he has suffered some losses as well. So when loss is injured party or injury, it means that there is some kind of loss. Torts, we'll study in detail. Consumer rights, employee protection, I gave you examples. These are in the civil domain. Most of the areas that we will discuss in our law are in the civil domain. Some will be in the criminal domain as well. Okay, we'll take a 5 minutes break before I take you onto the tour of differences between criminal and civil law. This is a very, very important area. And all the terms that we will study it, they have to be absorbed, they have to stick in your mind so that in the future, whenever we refer to those terms, you quickly know what it means and what we are referring to. So we will take a short break. Up until then, if you have any questions in your mind regarding the topic that we have studied so far, you could ask me and I will explain those when we are back. So 5 minutes break and then we will resume. All right. Now, our discussion will be on the topic and differences between criminal and civil law. You see, these two are very important divisions, and we need to understand them because the terminologies involved in them, the uh, their proceedings, their way of work. These are completely different from each other, and their end results are also different from each other. So we need to understand that accordingly. What is criminal law and what is civil law? Civil law is that domain, that portion of the law which sets out the rights and duties of people between themselves. And again, when we say person, it could mean individuals, it could also mean organizations. Meaning, civil laws are those which define the rights of one person towards another and that person duties towards the other person. Just like we said, employer and employee, seller and buyer. Seller has his own rights as his own duties. The buyer has his own rights, his own duties. So this area tells us about that. So that part of the law that deals with the duties and rights of people amongst themselves is the civil law. The person whose rights have been affected or violated, that is called the affected party or injured party, and they can claim a remedy from the wrongdoer. Later on, we will call him a defendant. Okay. Remedy means a solution. Now, we know that there are different types of solution according to the type of law. Common law solutions are monetary in nature. Equity, non-monetary in nature. Statutory, we will study it later on in different sections of our course. Whereas in criminal law, it is concerned with the conduct so undesirable that the state punishes the person who transgresses, the transgressor or who breaks the law. The key difference here is the word punish. You see, in civil law, you do not see the word punishment because that is not the requirement of the civil law. The aim is to compensate the affected party, not to punish the wrongdoer. He only has to compensate, cover the loss of the other party. Whereas in criminal law, the idea is punishment so that that other person does not do the same thing again. That is the main difference. Now let me give you a whole detail of the differences between these two. And at any point, if you don't understand any point, let me know and I will explain it to you again or will rephrase my answer. Okay, first one, civil law. Again, the purpose is to establish and uphold the rights of individuals, to regulate the interaction of the individual, how they interact with each other. Whereas the criminal law is to protect the society from criminal activities and maintain law and order in the society. So the objective is different. Now here comes the important bit. Who starts the case? Who goes to the court first and claims on the other party? It depends on the type of the action. If you are in a civil domain, that person will be called a claimant. In some cases, it is also called plaintiff. In some areas, in US, it is usually plaintiff. In UK, it is usually claimant or plaintiff, both can be used. This is the person who feels that their rights have been interfered with or affected. Whereas in criminal law, we say it is the prosecution. Remember a very key point here, that only the state can prosecute. Meaning, if somebody has uh, conducted a crime, committed a crime, only state or any institution of the state, for example, police, they can go against, take them to the court, and the process will be called prosecution. Now, wherever you hear the word claimant or plaintiff, this means that it is in the civil domain and it will be dealt in the civil law, civil courts. If it is the word prosecution, you will automatically understand that, or you should understand that we are talking about the some crime has committed or allegedly committed. Remember this. These words, therefore, I told you that these terminologies are important. For example, somebody tells one person you are being prosecuted. This means this is a criminal offense that he has to face, criminal allegation. Whereas if somebody said that you are I am the claimant in a case against you, this means that this is a civil case. Okay. Next, with the terminologies, decision, end result are different because the purpose is different. In civil law, because the intention is to compensate the other party, compensation means to uh, fulfill the loss that has occurred because of somebody's action. Therefore, we say it in this case liable or not liable. For example, I am a claimant against somebody and the court decides in my favor and against the defendant, then that defendant is liable to pay me certain amount, certain such and such amount. And if he is not, I could not prove my case, then that he is not liable. So again, whenever you hear the word liable or not liable, it means that this was a civil case. In criminal law, because the intention is punishment so that that action is not repeated by that person again, the term used is guilty or not guilty. This means that whether that person has committed the crime or not committed the crime. So again, if the word guilty or not guilty is there, you would automatically know that this is a criminal offense that we are talking about. What are the powers of the court? In civil law, the court can grant damages, which is the monetary reward. You see, the reward can be split into two areas, monetary and non-monetary. When it is monetary reward, it is called damages, means you have to pay for the uh, actions, for your actions, the loss that other person has suffered. Remember that in some cases, the loss is not monetary. This is a very subtle point that I'm trying to explain. Maybe it is a bit earlier, but I'm sure you will get it. For example, if somebody comes and honks horns all the time in front of my house and I am ill and I get mentally stressed out. Now, what is the amount of loss, monetary amount of loss that I have incurred? Obviously, this is my state of mind, the stress. I cannot give a monetary value to it. So will I get damages for it? Yes. I will go to the court. I can get an injunction. I can tell him, the court, to restrict him to not come in front in near my house, for example, 20 meters or 30 meters or 50 meters or whatever. That would be injunction. But I could claim for the monetary reward, even though I cannot equate my mental stress. The method is that I will tell my lawyer, he will calculate some kind of monetary reward. But the point here is not the loss, it is here the damages. If the damages are paid in monetary value, then that is called damage. The remedy is monetary, then it is called damages. But if it is not monetary, that can go into equitable area, which could be specific performance. Specific performance means that the judge tells another party to do something. Usually, it is when somebody promised something with me and now they are not doing it, I could go to the court and get it done. So when the court orders a positive, means do something, that is called specific performance. Performance, do, specific, exactly the thing that you promised. And injunction. Injunction means stopping somebody. So that is a negative command. Do not do something, just like I explained in the earlier house example. And there are other contractual equitable remedies as well, which we'll study in the contract chapter. This is the power of the court. So in civil cases, without one or two exceptions, there is only one exception in your course. We'll study it in the employment law. But other than that, courts cannot grant a punishment. Now, in criminal law, there could be imprisonment, there could be fine. In certain countries, there could be capital punishment as well. For example, death penalty is a capital punishment. So here, and this is a very key area that you need to understand, because based on this is our next area that we need to discuss. Imprisonment is, it damages the person's uh, reputation, maybe his life. Fine damages him financially, and other community services as well. They may create a problem for him in the future. You see, in compensation, you give the other party whatever they have lost, and then that is gone. It does not necessarily have to affect your reputation, but criminal law, that affects your uh, reputation. You see, in some countries, when you apply for a job, in the job requirement, they ask you specifically whether there has been any criminal charges against you, or you have been convicted of a crime in your country, because that goes to your reputation and character. This means that in a criminal law, a person's life can be ruined, it can be damaged irrevocably. But in criminal law, in civil law, that is not the case. Based on that, this is our important point and very important bit of your course. There are two areas: the burden of proof and the standard of proof. Burden of proof is also known as the onus. Onus means burden. Burden means responsibility. Responsibility of proof. Who has the responsibility to prove? A general rule again, and there again is an exception. We'll study it in the tort law. Generally, whenever there is a civil offense, you go to the court. Whosoever initiates the case, in civil case, that is the claimant, and in criminal, that is the prosecution. General rule is, whosoever initiates the case, alleges another person, he has to bring the proofs. Now, here is very important point. Consider the court situation. The judge is there, and there are two parties. One is the claimant and one is the defendant. Or in the criminal case, one is the prosecution, the other is the defendant. Now, let's take, for example, the civil case. I have alleged that this person is trying to make a house which is on my property. He should be stopped. This is not his right. This is my property. Okay, I am claiming this. So I have to bring the proof that this property is mine. It is not initially up to him to prove that this property is his, even though he may have proofs. Now, so first point is that who has the burden to prove, initial burden to prove? I will bring in the evidences. Later on, if my evidences are strong, then he can bring his own evidences. But if I am not able to bring any evidence or eyewitnesses to prove my case, then the case is gone. This is the initial important idea that you need to remember. Who has the initial responsibility? Whosoever starts the case. So we can say in the civil domain, it is the claimant who has the onus of proof and or burden of proof. And in the criminal law, in the criminal domain, it is the prosecution or state that has the burden of proof. So that was about the burden. Who has the initial requirement of bringing the proofs? Next, we discuss about the standard of proof. Standard means the extent to which the case needs to be proven. Okay. Extent means how good the evidences should be. It's about the weightage and not the number. Remember this thing. In law, we look at the weightage or strength of the evidences, not the number. I'll just give you an example. Okay. Now, I have alleged that this person is building his house on my property. The land is mine. I have a document which states that I have inherited from my father. That is a proper official document signed by the government. Proper everything is there properly. But I have only this proof. The other person has five witnesses who say that they have seen my father give him this property. They have nothing in writing. And then when my lawyer questions those witnesses, they prove to be shaky. Their statements are incoherent. They do not match with each other. One of them is a certified liar. He is not reputable in his community. Now, if you look at the number, he has five witnesses and I have only one evidence. But law does not look at it in this way. Law will see that who has the more powerful evidence. So the strength, I have a stronger evidence than one stronger evidence than is five weaker evidence. So I have a better case here. So this is how it works in the law. Now, important bit. First, you need to remember these terminologies. If you do that, that is fine. Uh, Further understanding is not a requirement of the course, it is the requirement of your career. In the civil law, the standard of proof is stated as it is on the balance of probabilities. Other word is by a preponderance of evidence. What does it mean? Slightly better. Whosoever, claimant or defendant, whosoever has slightly better or more weighted evidences than the other party means 51%. Whosoever has 51% better, the other one has 49% evidences, I have 51%, then the case will be in my favor. The decision will be in my favor. If the defendant has 51% stronger, mine are 14. I have the evidences, but 49%. So it is about on a scale which is called balance of probabilities or preponderance of evidence, slightly better. Whosoever has a slightly better case, he will win. That's it. But in criminal case, it is said beyond all reasonable doubt. What does it mean? You should, who should? Prosecution has to eliminate any reasonable possibility that they are incorrect. Why is that? It is a heavier burden. They have to give almost everything, a very, very, very strong evidences that this person is guilty of the charge without, like, there will always be some doubt. Remember that. Because there could be many, many questions. For example, it may come into mind, for example, a person has been accused of murdering somebody. Okay, the evidences are that he went to the murdered person's home. He had his own weapon in his hand. That person was murdered with the same weapon. There are eyewitnesses, but still, there could be a doubt, an unreasonable doubt. For example, a person could argue that maybe that the murdered person called him up. He told him to bring me your gun. I want to see it. And then they got into a fight, and he was defending himself, and that suddenly the gun fired and he died. There could be anything. You can fantasize anything. Therefore, it is not beyond all doubt. It is beyond reasonable doubt. There has to be a concept of reasonability that shows that yes, these situations say that he is the murderer. But this is a higher standard of proof for two reasons. One reason is who has the burden of proof, prosecution or the state. State has a machinery, state has its departments. They are in a better power to gather the evidences as compared to individual person. Second reason, the result of the criminal law can damage his reputation, can damage his life, can end his life even. Therefore, because the prosecution is making allegation, they have a higher burden of proof that bring all kind of heavyweight evidences to make sure that he is beyond all reasonable doubt he is guilty. Another important area is that why is this burden higher? Because you see, suppose it is a murder case and a person who has been alleged of that murder, of committing that murder, and you gave him the same standard like civil case on the balance of probability. Maybe he's not the murderer and the actual murderer is roaming free. And with the lower standard, you have eased out the case and you have given him the punishment. So this should not be done like that. So these are the basic differences between these two. Just a minute, please. Okay, my apologies. Now, um, keep thinking. If you have any questions, you can ask me. With this, a very interesting area of law I'm going to tell you. There is a possibility that an action of by a person calls for both domains to be activated. Like how? Suppose in a business, I've committed a fraud. Fraud is a criminal activity in UK. So I will be prosecuted. The courts, the criminal courts, the prosecution, the state will gather evidences against me. And the end result would be maybe I go to jail for that. I'm imprisoned for that because that is maybe the punishment for that fraudulent activity. Okay, fine. Now I'm in the jail. But what about the people's money who I have taken because of that fraud? What will they get? They get nothing out of my imprisonment. Well, who will give them their money back? But they cannot charge me with a criminal offense because crime is charged by the state. So what is the solution? They will go into the civil courts. They, for the same action, for the same fraud, uh, they will start a civil litigation against me, and I will have to hire another lawyer and deal in the civil domain as well. Another interesting thing is that it is possible that I may be relieved in the criminal case and I may be held liable. I am not guilty in the criminal case, but I am liable in the civil case, meaning because of the difference in the standards of proof. In the criminal case, the standard of proof was way higher. The prosecution could not prove their case. They had evidences, but I had a stronger defense. They could not prove me wrong. But in the civil case, because the standards are lower, I had the evidences, but those were not that much strong as the claimants. So in that case, I will lose the case and I will be held liable. So remember this thing, that this is a possibility that for the same action, I am held responsible in both the cases. And it is also possible that in one domain I get free, in other domain I am held responsible by the courts. Okay. So with this, we would end our today's session. Uh, Before ending it, actually, I'll need to show you a video. It is a very important video from the geographical point of view. It does not have such a specific bearing on our course content, but because most of us have never been to UK or we haven't studied its geography, we need to understand what we are studying. So because should be a mental picture when we study different types of courts and different types of jurisdiction. So stay put. I'll put in a video and it will tell you about the geography of UK. How does it work? What is United Kingdom? What is Great Britain? What is England? You need to understand its differences. Just give me a minute. I'm starting this video and let me know if you are not able to hear the sound. I will check it out for you.
Most people don't know the difference between the United Kingdom, England, and Great Britain. Are they all the same, or is there a difference between them? And which one is correct? Let's find out. These are the British and Irish Isles, a group of islands located off the northwestern coast of Europe, primarily consisting of Great Britain and Ireland. It's important to note that Great Britain and Ireland are geographical terms, not political ones. Great Britain is the largest island, while Ireland is the second largest. Now here's where it gets interesting. Great Britain consists of 3 countries, England, Scotland, and Wales, each with its own flag. In contrast, the island of Ireland consists of 2 political entities, the Republic of Ireland and Northern Ireland. The southern part, officially known as the Republic of Ireland, is a completely separate country and is not part of the United Kingdom. But what exactly is the United Kingdom? The United Kingdom is a country of countries. It includes England, Scotland, Wales, and Northern Ireland. All these countries are considered co-equal under the Union. The United Kingdom is a political union, unlike the geographical term Great Britain. People from these countries are referred to as English, Scottish, and Welsh, while those from the Republic of Ireland are known simply as Irish. People in Northern Ireland may identify as Irish, British, both, or Northern Irish, depending on whom you ask, as there's no single identity that applies to everyone. So, to sum it up, England is a country, Great Britain is an island. The United Kingdom is the political union that includes England, Scotland, Wales, and Northern Ireland.
Okay, so now you would know this basic idea. In the future classes, when we will be referring to different jurisdiction and district areas, you will have a certain frame of reference for that discussion. So we will end today's session with this. If you have any questions or queries, you may please ask in this chat section. I will be uploading these slides on the portal as well, and this video as well, and along with it, different resources like the BPP book and the kit as well. So if you have any questions or queries, you may please ask, or otherwise, I'll end today's session. Thank you very much. Take care and goodbye.